All right, welcome back. All right, very well, very well. By the way, I figured out what's wrong with the audio. The mic I was using was not good. So I ordered a new mic and it should be arriving here by next week, so be fixed. Somebody complaining about the audio, so I got that to take care of. Okay, any questions? Anything in your mind? No? Okay, so we are basically done with the first half of the class. In most law schools in the country, you have 2 units of ConLaw. You have ConLaw 1, which is called the structure of the Constitution, which is the Article 1, Article 2, Article 3 stuff. And ConLaw 2 is what's often called rights, which involves the Bill of Rights and the 14th Amendment. Now, I think it's a misnomer. I think all the provisions of the Constitution are aimed in the same direction, protecting individual freedom, but they're separated in most classes. In fact, in South Texas, you may be following this uniform bar exam. Are you aware of this? The uniform bar exam. Do you know what this is? Texas is very likely going to be adopting the uniform bar exam, which has pros and cons. One of the pros is if you pass the Texas bar exam and your score is high enough, you might be able to waive it to other states as well right away. So it's a much more portable degree. It's very likely that you will be taking it. When you guys taking the bar? 2021? 2020? 2021, yeah. So by 2021, it's a very high likelihood that you'll be taking this new bar exam. The downside is your curriculum was designed towards the older exam. So there very likely are classes that were not required for you that may be tested on the new bar exam. You guys are panicking, I know. So we're meeting with this to try to change your curriculum for the incoming 1Ls. Doesn't help you that much. One second. But one of the upshots is we will likely be having 2 units of ConLaw 1 and 2, starting next year. Not so much you. I know. One of the reasons why is the First Amendment, which I teach for 1 day, it's all I have time for, is tested on the uniform bar exam. So I'll be teaching in the spring if you can take one at night, but probably don't want to have me again. Probably not good for your health. But just be on the lookout that if you are the sort of student who wants to take every single bar class, which I don't necessarily recommend, but some people do want to do that, you may have to rearrange your planned schedule and what classes you want to take. Yeah.
When will the uniform bar come into existence? 19, 20, 21?
Could be 19 or 20. Could be either one. You probably will hit it for sure. My day students are taking the bar a year earlier than the evening students, so they may or may not hit it, but I think you guys will hit it. Well, but the downside, I mean, the upside is every year they delay it, they're putting Texas students at a competitive disadvantage if they want to be portable. So the longer they drag it out, now if you want to stay here in Texas, it's probably not to your advantage. But anyway, we're having a huge meeting about this next week, and I will be on the committee about this, so I'll hopefully have more to report. But anyway, so starting next year, more likely than not, ConLaw will be 2 units. So where we finished yesterday, it was basically the first semester ConLaw. So you know I move real fast, my friend. Yeah, I cover a lot of ground, unfortunately. So you're actually prepared for all of ConLaw. You don't have to worry about anything. I give you the entire thing. But yesterday's class, or I guess Monday's class, that's like ConLaw 1. I skipped around a little bit. And today is class, 12 through the end is basically ConLaw 2. And ConLaw 2 starts with the 14th Amendment and then goes to the First Amendment. And I might do some other stuff as well if I have time, which I think I will, which would be wonderful. Yes, sir.
So if they do work on county bar and we do expand to 2 classes, which one would you recommend we take to be fully more prepared?
To be in terms of constitutional law?
Yeah.
The only thing you're probably missing from me is First Amendment, which I'm teaching in the spring. And the only reason why is I cover it for 1 day. I just don't have time to cover it for the entire semester. But you've actually learned everything you need to know about structure and rights. I give you everything. I don't skip around. That's why the reading is so damn long. But I'm giving you everything you need to know. But First Amendment, I only go for one day, so that might be the only thing. That's it. And I think the First Amendment generally is important to know as human beings and citizens of this country, but for the bar, you'll need to know it as well. Okay? If you have questions about this, you can ask me. Again, it's all very new to us. We're trying to be as fair as we can to the students. We'll probably have some information for you at some point, but the faculty are still trying to determine how the incoming 1Ls handle it. But we'll have a bridge of some sort for the people who already started. There are upshots, though. For example, tax is not in the bar. Whoa. Yeah. Possibly. Well, again, I don't know when these changes will go into effect, but income tax is not on the uniform bar exam. So I mean, there are upshots, right? There are some classes that are just not tested. So when I say tax, like yay, whatever. But okay. Any other questions on this? If you can ask me after, if you don't want to ask him. Yeah.
If there is a bridge gap for the First Amendment, would you be willing to offer maybe like a seminar or something that could like bridge that gap in the future?
I'm teaching in the spring, Monday nights. That's what you get. Oh, you're asking for a special class?
No. What I was saying is that's not what I was asking. I'm just saying that if you've got 95% of it in the existing curriculum and you're only missing the 5% on the First Amendment, that would be a lot less to cover than a whole semester.
It's a full semester. So if you look at the last 4 chapters of your book, it's all First Amendment, basically.
You teaching it every spring?
At least this year. I don't know about the future. They don't tell me in advance what I'm teaching. I don't know until basically one semester in advance. But I'm definitely teaching for the spring. Anyway, it's your call. If you want me to get. Do you have an elective this spring or no? Anyway, well, we can sort this out later, but just be on the lookout for these things. And I don't know the answer about tax. I will ask about that because yeah. Anyway, anything else? All right, let's do a question. Let's do a poll question, please. Let's do a poll question, and I want to use this as a jumping off point. If you notice, the reading today was quite long, but there's only one case, which I'm sure you all either appreciate or hate me for. I don't know which one. So the question for today is this. The Constitution of 1787 excluded slaves from citizenship. True or false? Constitution of 1787 excluded slaves from citizenship. True or false? Okay, another 10 seconds or so. It is a weird question. Hard question. All right, Jesse. I think you're first, if I remember correctly. She actually came to my office and reminded me to call on her first. So that was,
Oh, you might be mistaken. That wasn't me.
That was the other Jesse.
That was the other one.
Okay, we'll call you.
No, I'm just kidding. You're really
All right, Jesse. So before I ask you your opinion, right, on this question, I got to ask you an important question. What is citizenship? What is? I mean, it's right there in the question, right? You all answer this question. I'm asking you now a basic question. What is citizenship?
So I would say that citizenship is, well, you could be a citizen federally or a citizen by the state, and I believe that's when you're a person of the state that is legally, I guess, like you get the privileges and everything in the Constitution, and you're
Okay, I want you to define citizen without using the word citizen in a sentence.
I don't know if I can do that.
Well, that's the question.
So I think it's a person that follows. Oh my gosh, I don't know.
Oh, wow. This is a hard question, by the way. This is not a fair question either, because it's not in the reading or the Constitution or anything. But Dana, words in the question. You all put an answer in there, right?
Mm-hmm.
What is citizenship?
I think citizenship is a person who's protected by government.
Protected by government.
Which they live in, like in the area that they live in.
So is every person in a country a citizen?
Oh. No.
Are non-citizens not protected? Under your definition?
Under my definition, yeah.
Glennis, what do you think?
Well, they don't have certain rights if they're not a citizen.
Okay. Why is that the case?
Because they're like recognized as being like part of, and then they fall under like the rights that were given them, like via Constitution or some other document.
Okay, Marky, what do you think?
I think that only a citizen would have like the rights and privileges that like the Constitution or the law of the land provides. So
Does the Constitution say, Markia, who is a citizen?
no, it just talks about a person.
Does it talk about citizens, the Constitution? Oh, you're not correct.
No.
It does.
Okay, then.
Well, the question was, does the Constitution mention citizens? It does. And it does in a very boring place that you all study in Civ Pro and probably didn't even think about. You want to take another step?
Diversity of citizenship?
Yeah. You never thought about it, right, when you guys did Civ Pro. But what does it mean to be a citizen of one state suing a citizen of another state? Right? The Constitution uses this term citizen. Does it define it, Markia?
No, we have to define it ourselves.
So, Lucian, how then can we answer this question if the Constitution doesn't define what a citizen is?
They kind of do.
Okay, tell me how.
Article 4, Section 2.
Okay.
If they're not talking about what citizens are entitled to.
Okay, so we got to start, right? Article 4, which actually is on the board. No, I have Section 3 up there. I have to scroll. I can't scroll from back there. So we have Article 4, Section 2, right? Here it is. A lot of stuff in Article 4, Section 2. It's chock full of stuff. It begins. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. All right, Lucian, you call that provision out. Does that tell us who is a citizen?
Kind of. They could have been citizens instead of person.
Yeah, but Lucian, let me push you on that one, right? What is a citizen of a state? What does a citizen of a state suggest?
Privileges and immunities, such as they can vote.
No, but if you're a citizen of your state, what does that suggest that you may not be?
Not a citizen of the United States.
Or a citizen of United States. So from the we're just talking text here, right? We're not talking any history. We're only talking text here. We have this very important provision. Very important provision. We don't talk about it much anymore. It was really important back in the 1800s. And it says, the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. So, Jeremy, let me ask you a question. Was your hand up before with the question? Okay.
That was regarding.
Okay. Let me call on you for a new question. Okay. Okay. So, the citizens of each state shall be entitled to the privileges, immunities, blah blah. Okay. Does that mean that all the citizens nationwide have the same rights?
Federally, yes.
Where do you get that from? That if I'm a citizen of New York and you're a citizen of Texas, that we have the exact same rights?
Well, under the federal law is the supreme law.
I am talking about this provision of the Constitution. That's all I'm talking about. I'm a citizen of New York, and you're a citizen of Texas, does that mean that we have the same privileges and immunities? I'm only talking about this one clause. What does it say? Read it.
Well, it says the citizen of the state shall be entitled to privilege and immunities as citizens of several states. So all of the states.
That's not what it says. That is not what it says. So let me ask you this question differently, Jeremy. All right. I am a citizen of New York, and I travel to Texas. I'm still a citizen of New York, all right? I haven't lost my citizenship. I'm just visiting Texas.
Right.
We're both in Texas. Can Texas treat me differently than it treats you? Can Texas give you certain rights that I don't have as a visitor?
I would assume that, yes, there are certain rights that you can, for example, you can vote in state
No, I'm talking about privileges and immunities. Just read the clause. I want you to focus on the text, right? What exactly, James, what exactly is provision doing here? The wording's a little weird, but I want to actually drill this point.
This is giving each state jurisdiction over their people and giving them special privileges and immunities and rights.
And what from a visitor to that state? I visit Texas, New York, and I'm a New York citizen. Can Texas deny me the privileges it gives to its own citizens?
Yes.
No, Marcus?
Well, just ensure that everyone's treated fairly.
Within?
In the state.
Yes, sir, that's it. This is what's called a non-discrimination provision. Okay? The wording, I admit, is a little bit weird, but it's a non-discrimination provision. What it says is the citizens of each state shall be entitled to the privileges and immunities of citizens in the several states. So if I'm a New York citizen and I go to Texas, Texas can't deny me the privileges and immunities. Now, what these privileges and immunities are, we'll get there later, but they're just certain rights. It's a non-discrimination provision. Why is this provision so important? Why is this clause so important? Here's what happened. During the era of slavery, imagine this. You had a ship that traveled from Massachusetts, which was a free state, down to South Carolina. Right? So, travels down the coast. You have an African-American sailor on that boat. He is a citizen of Massachusetts under state law. No questions asked. He goes out to South Carolina, and he gets arrested and thrown in jail for being a slave. But he's a citizen of Massachusetts. He's a citizen of Massachusetts. Massachusetts thinks he's a citizen, but South Carolina doesn't. Were he a citizen of South Carolina, were he a citizen of Massachusetts, they'd have to give him the same rights they give to native South Carolinians. But if he's not a citizen, then he doesn't get those rights. So this was a huge controversy. Frederick Douglass wrote a lot about this. He was a great abolitionist. Yeah, sure. Yeah, so if he's a citizen of Massachusetts, he has to be treated the same way a citizen of South Carolina would be treated. But if he's not a citizen of Massachusetts, he doesn't get any rights at all. This is why the distinction between a person and a citizen makes a really big deal. Right? We discuss in the Constitution, doesn't use the word slavery. He uses other persons and such persons, right? Such, euphemisms. But this matters because when you had these sailors traveling down from free states to slave states, and they were held in captivity, and they said, look, I am a citizen of my own state. You have to treat me the same way you would treat a citizen of your own state. The other side said, no, because you're not a citizen anywhere. And because the Constitution does not define citizenship, this is why I had to go up and down the road to get an answer, there was no resolution of this issue. If you read Dred Scott and Justice Taney, he makes a really big deal about this. Right? And this is leading into the case. The reason why Dred Scott is the opinion that it is Justice Taney had to make sure that the people of African descent could not be citizens. Because if they were citizens, they would be entitled to the same privileges and immunities that white people got. And he could not bear that. He could not countenance that conclusion. So even though Dred Scott, at its most basic level, was a question about diversity citizenship, which is how it got to court, right? That was the basic legal issue. He had to knock out every conceivable basis on which citizenship could be granted. Adrian.
So on what basis did they determine that a person from Massachusetts was not a citizen? Because if they based it on their definition, but Massachusetts has determined under their, so Massachusetts said, look, you're a citizen in my state. And then North Carolina is saying, but in my state, I don't consider you a citizen. Then how can North Carolina have this definition supersede what Massachusetts said?
Oh, what a good question. So let me repeat her question, right? She's saying, if Massachusetts law says one thing, right? How can South Carolina say that Massachusetts law is wrong? This is why Dred Scott has such god-awful language. When he says basically it's the law of God, that God created the race as inferior. I want you to understand why he did this. He was trying to say that the laws of God trump whatever Massachusetts said, that they're wrong. This is why the opinion goes so far, all the way out all over the place, to say that these laws cannot possibly be right because there's a superior law that trumps Massachusetts. Even if Massachusetts calls a person a citizen, they're wrong. And he made that the supreme law of the land by virtue of his decision. You got that, Adrian? Yeah, Moniqua?
I think I'm struggling with what you said, the meaning of privileges and meaning of citizens in the several states. What exactly?
It's a non-discrimination. It's a poor way of phrasing. I agree. It's not clear, but it's a non-discrimination provision. That means if I'm traveling from New York to Texas, right, and I'm a New York citizen, Texas must give me the same privileges and immunities it gives to its own citizens. You can't treat out-of-staters differently. That's generally what it means. So, for example, there's litigation about this today, right? I'll give you an easy example. California passed a law that said if you move to California, you can't apply for welfare for, 6 months or a year, right? In other words, if you were a California citizen, you got these benefits right away. But if you travel to California, you were denied them for 6 months, whatever it was. And the court said it violates the Privileges and Immunities Clause. But I just the basic gist, right, of why Dred Scott was what it was, and there's a lot of reasons, was to deny that states could have free black people that were citizens. Because if one state, if Massachusetts could have a citizen, that means South Carolina had to respect it. Understand? But the flip side, if Massachusetts could not have a free black citizen, that means slaves could freely travel there and not be emancipated. Right? What this decision did was paving the entire country from coast to coast as slave territory. Right? Before Dred Scott, we had this uneasy peace where you had some northern states above that line, the 38th parallel, right, were free, and you had some of the southern states where there was not freedom. But after this decision, it was coast-to-coast slave. Because now a person could bring a slave to Massachusetts, and that person would not then be emancipated.
So are you saying when you said that the superior law is the law of God?
Read his decision. Yeah.
It was to justify it. Because just going by the wording of the Constitution, that clause in and of itself, that sort of kind of trumped his.
Trump Massachusetts law, for example.
Okay, so this trumped the Constitution.
Yeah, and when I say God, I don't mean any particular religious sect, but he's saying there's a higher power. If you read his decision, he makes this with that. He says the races were created unequal. That he says this in very clear language. Yeah, Kanisha?
Yeah, so I was reading that part, and I was thinking, I wonder where you got that from, because there was Adam and Eve, and then that was it. And then everybody came from Adam and Eve. So it kind of blew my mind a little bit, because I'm thinking, you got to be kind of slow. It was just two people. There was one man and one woman. And then you had all these people that came from that. So I was like, do you believe in evolution or something? Do you think some people came from Adam and Eve and some people came from
So let me just take that. There was a very strong strand of Christianity that actually endorsed slavery. And you know the story of Noah and Ham? You know the story? So one of Noah's sons, right? I'm Jewish, but I don't know. But one of Noah's sons, Ham, his name was Ham, was described as being dark. And a lot of teaching said that the fork from the white race happened at that point. And that was an inferior.
Blows my mind.
Anyway, but my point is there was a very strong
religious strand in the South that actually believed that slavery was consistent with biblical teaching. So,
You could say they actually, their story or
Yeah.
their ideology supported their
Yeah.
mission or their.
Yeah. But the point I want to stress is the reason why, I think just Adrian's question framed it well. The reason why Tawny went out of his way and said this is a matter of like nature, this is not just us, is that the laws of the state cannot supersede the natural order. Does that make sense, Adrian?
The natural order.
Oh, of course, this was his belief. I mean, there's very little law behind what he's saying, right? He wasn't citing much. So there's so much about this case, but I just want to get the basic. Let me set the basic facts, and then I'll call whoever's next. I think Justin, you're on call eventually. We'll get there. You're gonna be holding pattern. Yeah, you're like the holding pattern with this bad weather. You have to just keep circling the airport for half an hour. It's my life. Okay, so the story of this case actually begins very early in our republic, and it begins with the Louisiana Purchase. If you can start it there, right? Louisiana Purchase. I have the map up here somewhere. So the original United States was fairly small. It was more or less states along the eastern seaboard. And over time, they acquired some territory. They fought here and there. But the big expansion came in 1803, which President Jefferson acquired the Louisiana Purchase. And just as a side note to mention this, it's not clear that President Jefferson had the power to buy the Louisiana Purchase by himself. This was actually my final exam last year, or maybe it was my midterm last year. I can't remember. It was one of my exams last year. And the reason why is we have this clause of the Constitution, which no one cares about, right? No one even cares about this. I took a class on it, but no one cares about it, right? It's called Article 4, Section 3. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States. Okay? There's no express provision in the Constitution that allows the government to buy new property. There's no such clause. There's clauses about admitting new states and how to admit states, but there's nothing that says we can buy property. So generally, this provision that's called the property clause is viewed as the basis of how Congress can acquire property. But again, it's Congress that acquires property, not the president. Jefferson doubted that he alone could do this. He did it anyway because the times were kind of tight, but he had doubts whether he had the power to acquire property. Okay, so then why is this relevant? After the Louisiana Purchase, there was a dilemma, right? Eventually, these territories would become states. And as states, they would have members of Congress and they'd have senators. Would these states become free soil, that is, slavery is prohibited, or would these states become slave? And there wasn't a good compromise on this that actually made everyone happy. Because if you had more slave states, under the 3/5 compromise, as it were, those states would have an extra helping of representation in Congress. Right? There's a reason why that virtually all the American presidents up to the Civil War were Southerners, with the exception of John Adams and John Quincy Adams. It was actually largely the boost in population from Southern states by virtue of the 3/5 compromise. Right? So except for John Quincy and John Adams, I think almost every president up to the Civil War was a Southerner. So there was a compromise that was made, several compromises, where, this green line is not perfect, but it's more or less represents it, where states that were above that green line would become free soil, and states that were below that line would become slave. And this is the 3630 parallel. And this was known as the Missouri Compromise. Because the deal is Missouri is actually just above the line, but it was admitted as a slave state. I call this the Missouri Compromise. It wasn't much of a compromise. This was basically kicking the can down the road. This was not sustainable. And virtually everyone agreed that this would not last. I think Lincoln said something, I'm paraphrasing, but Lincoln said the country will either be all slave or all free, but it can't be this middle of the road thing. It could not endure with this division. And the Dred Scott case illustrated one of the reasons why this could not endure. Why? Because if a slave owner from Missouri travels north to Illinois, which is a free state, and to the federal territory in what's currently Minnesota, Fort Snelling, what happens to his slave? That is, if the local jurisdiction says we emancipate you, but the court back in their home state says no, we do not, then you have this really serious, intractable problem. Keep in mind Prigg. I know we said that the second week of the semester, and you're all thinking about enumerated powers and necessary and proper, but that case was really big for slavery because it said you can have slave catchers dispatched to northern states and local jurisdictions cannot prohibit that practice. That's what Prigg said. I mean, we talk about necessary and proper, all that good stuff, right? But it was actually a case about slave catching. All right? So between Prigg and the Missouri Compromise, you had this weird situation where slave catchers go north to bring slaves back, right? And people who brought the slaves north cannot be emancipated, which is what I'm trying to say. This was trying to pave the country slave, red, so to speak, from coast to coast, right? Between Prigg, the Missouri Compromise, and Dred Scott, it was trying to make the entire country amenable to slavery, even in jurisdictions that did not want it. All right, everyone with me? All right, Justin, now it's your turn. You want to give me, please, the facts in Prigg? Sorry, wrong case. Dred Scott. He panicked for a second. Oh, my God. That was a month ago. I can't remember that far. Yeah, okay, give me the facts, please, in Dred Scott. Yeah, I'm sorry. That was very mean of me. I'm sorry.
So Dred Scott was a slave to Dr. Emerson and was a U.S. Army surgeon. Emerson and Dred Scott moved from Missouri to a military post in Illinois, and from Illinois they went to Minneapolis, Minnesota, where Dred Scott was left.
But it wasn't Minneapolis yet. It's present-day Minneapolis. It was actually a place called Fort. Yeah, it was called the Wisconsin Territory. It's present-day Minneapolis. If you ever fly to the Minneapolis airport, the airport's about a mile from Fort Snelling. It's very close. But it was a federal territory. It wasn't yet a state. So just want to clarify that. All right, go on, Justin.
So this was a free territory.
Good, yeah.
And Dred Scott stayed there while the doctor went off and did Dr. Scott.
Okay, that's good.
Scott ended up marrying his wife, and then Emerson, I believe, got married.
What about their kids? Yeah.
Dred Scott to come back and
Good.
be a slave, you know.
Okay. And what about Scott's kids?
I'm not sure. I don't remember anything about the kids, but I remember Scott died and left
Yeah.
slaves to.
No, the kids are important. Andrew.
Scott, but Emerson
Yeah,
died.
Andrew. Talk about the Scott's kids.
One of the kids was the one who was like administering the estate.
No, Dred Scott's children.
Scott's kids.
No, not Emerson. Dred Scott's kids. You just want to do it again?
Yeah, they were born in a free territory.
Well, one of them was just me where they both were born. Oh, he had two kids. I'm sorry. Was that in your book? Okay, he had that. I'm sorry. They had two kids. They had two kids, Eliza and Lizzie. Eliza was 14 at the time, was born on a steamboat north of the line on Missouri. So she was actually born on the waters of the United States, which played into the case. The second child, Lizzie, was born in Missouri on Jefferson. So technically, Eliza was born on free soil, though I guess it was free water, as it were. And Lizzie was born. I'm sorry, it wasn't in your book. The facts are in my head and not always in what's in the book. Okay, that's fine. All right, so Andrew, so walk me through the posture of the case, right? How did this case get to federal court and the Supreme Court? Just walking through the case.
Yeah, so Dred Scott sues Emerson for his freedom.
Okay, where does he sue?
In Missouri? Minneapolis.
Where's Kristen?
Yes.
Yeah?
What?
Didn't you say that you went there to a mock trial or something?
Yeah, in 8th grade.
Tell us about it.
Well, I grew up in Missouri. So we went to St. Louis in 8th grade, and we did a mock trial of the Dred Scott case. And I'm obviously black, so I had to sit in like a peanut gallery style booth while my classmates acted it out. Like one of my white classmates was white, my black classmates was Dred Scott. You know, the whole thing. But it was really great, and yeah, we learned a lot. We talk about Illinois here, but actually in Missouri, the big deal is that because of the Missouri Compromise, Missouri was a slave state and Kansas was a free state. And so actually if you go to Lawrence, Kansas, the high school there is called Lawrence Free State High School because they want to emphasize they were a free state, Missouri was slave state.
Thank you for that.
And yeah, and that's the
So if you ever go to the famous St. Louis Arch, right in downtown, it's actually on Dred Scott Place, or Dred Scott Road, whatever, Dred Scott Place. And there's a statue of Dred and Harriet Scott standing outside the courthouse. I think it's pretty fitting. That was actually where the trial was. I took some more pictures.
Oh yeah, that's the picture I tried to say.
See, I got you. Twitter is everything. So I'll just walk through what happened. Scott filed a motion for what's called emancipation to basically free himself. He was being helped by some wealthy benefactors. He didn't have all this money by himself, but he was being helped out. Emerson died, which I think Justin said a minute ago, and Dred Scott's wife, Emerson's wife, was somewhat of a curious character. It wasn't clear whether she wanted slavery or not, and then she got married to someone else, and the person she got married to apparently was an abolitionist who did not favor slavery. So she basically assigned, if you will, the ownership of Scott to the brother of Emerson, who was a citizen of New York. Right? Again, New York, he was in New York and they were Missouri. So in the first go-round, Scott sued Emerson, the brother. By the way, the brother's name is Sanford, but it's marked as Sandford with a D, and there's an error, but his name was Sanford. Scott sued Sanford in state court, in this trial court in Missouri, right by the St. Louis Arch. I'll show you these pictures later, maybe. Oh, yeah. The actual courtroom was destroyed, but they tried to recreate it for what it was supposed to look like. So I'll just give you an approximation. They sued for emancipation. Now, under the law in effect at the time, right, Missouri had a policy that said, we follow the law of where something happens. So if under Illinois law, a person travels there as emancipated, then Missouri would honor Illinois law. This is called choice of law. By the way, that is on the bar now. So you might have to take that class. You should take it. It's a good class, right? But under choice of law, a Missouri court will apply Illinois law, right? And says we will honor the decision of Illinois. And this is a general idea. We want to honor the law of where something happens. If a person's emancipated in Illinois, Missouri court should follow it. The Missouri Supreme Court, though, changed course. And this is important. The Missouri Supreme Court, in a very important opinion, ruled that we no longer follow Illinois law. It goes against Missouri policy. It goes against Missouri public policy. Therefore, under Missouri law as it stands now, you are not emancipated by virtue of your travels to the free state of Illinois. Tawney mentions it at the end of his opinion. He references that under Missouri law, that's what it is. They changed it for Dred Scott. They basically reversed themselves. And Kristen, maybe you remember this. I don't. I think there were only with 2 or 3 judges in the Missouri Supreme Court. It was a very small court. Do you remember this?
Yeah. So when we did it, it was because we were here. We were actually in the courtroom, and there were 3 of my classmates, and then there was only 1 representative for the state, and then his wife wasn't allowed to be in the courtroom at all.
Yeah.
So.
Yeah. It was a very small court. It was 2 or 3 judges. I think there was a dissent also. Memory. Check my tweet storm later. I tweeted about this a few months ago. I don't remember the details, but it was a very small court. Anyway. Yeah, Mark.
Do you think that the Supreme Court, the Missouri Supreme Court, they changed course because they wanted to avoid the issue and not face them?
I don't know why. That might be plausible. I think that's absolutely plausible. I don't know, but they definitely changed their law in response to Dred Scott's case. Absolutely. I'm not sure why. I haven't done any research, so I'm not sure. But Tawney sure as hell did. So then we move forward. Dred Scott did not appeal the decision from the Missouri Supreme Court to the U.S. Supreme Court. He did not appeal. Maybe he could have, he didn't. Instead, he filed a new lawsuit in federal court. Right? He realized, okay, I'm screwed from the state court. Now, Erie, I say Erie, people get very scared. The Erie doctrine, right? I think Erie was wrongly decided, so that aside. By the way, Erie was decided the same day as all these other New Deal cases. They're all attacks on FDR. It's all bad. But Erie had not yet been decided. I don't think Swift v. Tyson had decided yet. But in theory, a court sitting in diversity would apply the law of the state. So in theory, the federal court would be applying Missouri law, but not necessarily. But Dred Scott thought, okay, I might get a better shake in federal court than I did the state court. He was probably right about that. So he sued in federal court. But the question there wasn't on the merits, right? It wasn't about whether he was emancipated, because the first question that any court has to ask itself is, do we have jurisdiction? The basic question every court's got to ask itself, do we have jurisdiction? If the court lacks jurisdiction, then the case is dismissed. Now, let me just put this point out there and I'll move on. I'll go into Sahara in a minute. If indeed Scott was not a citizen and the court lacked jurisdiction, the Dred Scott case should have been 1 page long. Maybe a paragraph. Maybe a sentence. The petitioner is not a citizen, dismissed for want of jurisdiction. You're reading a piece of cake, right? Man, that'd be easy. One page, right? One sentence. Petitioner is not a citizen of the United States. Or, I'm sorry, he's not a citizen of Missouri. Therefore, this court lacks diversity jurisdiction, dismissed. What I want you to understand the rest of the class between now and whenever we finish is why was this not a 1-page opinion? Right? Why was this not a 1-sentence decision just kicking the case for lack of jurisdiction? And here's the answer. Because some state court somewhere would reach the issue where there was jurisdiction. Maybe it wasn't Missouri, maybe it was another state. But eventually some state court would reach the issue where there was jurisdiction proper. And that would get appealed to the Supreme Court. What Justice Tawney was trying to do here was resolve the entire shebang, right? Try to resolve the entire issue from coast to coast in one decision. He was trying to resolve everything. He thought he was, so smart, and that this was going to, resolve all these conflicts, and just make everything cool. I don't know if he started the war, but I do want to address that, right? I don't know that he started the war. He maybe accelerated it, or he maybe brought it quicker, or maybe. Yeah, maybe he lit the. Maybe he. I don't know if he lit the fuse, but he definitely poured gasoline on it. How about that one? I don't know what metaphor you want to use. Tanisha?
So when I was reading it, I didn't think that he was along the lines of the opinion being wrong, because he was trying to figure out all the different ways that he wanted to cover the jurisdiction issue. I was thinking that it was long because he was trying to find every crappy excuse that he possibly, he was really searching. And that's one thing I've kind of noticed. It seems to me that when the opinions are really long, there's a lot of additional stuff in the opinion in an attempt to justify whatever it is that you want to justify. So whenever it's a reach, and it was a reach. So he was, he didn't cite much law. It was really his blah, blah opinion. And he was talking about, God and all kind of crazy stuff. So it seemed to me that it really was his attempt to justify something that he knew there was no justification for, not particularly to cover all jurisdictional issues for time to come.
Let me tell you something. You have an edited version of the case. No, if you want, now, you're not going to read the long one. Do you want to know why? The original case was so long that the clerk of the court, the reporter, edited parts out. He said, this is way too long.
Because he was trying to find stuff.
The opinion was, I just Googled it. I think it was 150 pages long. It was so long. And by the way, there's no computers. It's all handwritten. The guy wrote this thing by hand, basically, with a quill, right? But the opinion was so long that they had to actually, the clerk of the court edited parts out. Because this is insane. Now, one other bit that I think I might have mentioned somewhere, Tawney originally was not the majority opinion. He originally was a concurring opinion. And I think, who's the second one? Justice Curtis? No. Curtis dissented. Was it Nelson? No, no, it's not in your book. I'm sorry, that's why. No. Okay, it's I think Justice Wayne. It's not in your book, but there was a concurring opinion that was actually supposed to be the majority, and somehow Tawney flipped it. So there's a reason why I think Kenesha makes a fair point. He reached for a lot of crap, if I can paraphrase you, and he was really trying to find stuff to get where he wanted to go. All right. So the case came to the court. The issue itself was narrow, right? Was there jurisdiction? Okay. So the first question is, Sahar, for you, you've been waiting patiently. How does Justice Tawney hold that there is no jurisdiction for the federal court here? What's the basis of his ruling? Not just citizen of the United States, not a citizen of what? Very particular. What does a diversity citizenship statute require? A citizen of... Okay, so you had Sanford was a New York citizen. Was Scott a citizen of Missouri? Okay, why? Yeah, a little bit louder. I don't even hear up here.
So he signed a enslaved in the United States and held that descendants of African slaves could never become citizens even if they were emancipated under state law.
Okay, why could they never become emancipated under state law? Why was that the case?
Because he talked about like the intent of the framers in the Constitution.
Okay.
They didn't intend for the African slaves to be citizens.
Okay, and just what's that intent? I'm looking for what evidence he puts forward. He gives some textual evidence. Let's talk about the text of the Constitution. You got enough. Austin, what text does Justice Tawney cite from the Constitution as evidence that the framers did not intend Africans to ever become citizens of states or the United States, for that matter?
Well, I think he uses the word citizens first.
Okay, right, but what about the Constitution excludes? This was my question at the outset, right? What about the Constitution excludes slaves from the category of citizens? What clauses does Tawney bring forward? He cites stuff.
I think he cites that states can make, or you can be a citizen under the states, but that doesn't necessarily make you a citizen under.
No, Yara?
I think, well, he talks about how in the Declaration of Independence, they say that we want to see self-evident that all men are created equal, that they're endowed that are created for unalienable rights and unlimited life, liberty, and happiness. But then he goes on and says that even though these words would seem to embrace everyone, he says it's too clear for dispute that the enslaved African race were not intended to be included and form no part of the people who framed and adopted this declaration. For if the language as understood in that day would embrace them, the conduct of the distinguished men who framed the Declaration of Independence would have been utterly and thoroughly inconsistent with the principles they asserted. So basically he says that although the Declaration of Independence says that all men are created equal, had that been the truth and that been their intention, then the framers of the Declaration of Independence would not be doing that themselves.
So Yarn gives us a historical argument. The text says all men are created equal, and as a matter of history, that's simply inaccurate. They were not equal from the outset, from the get-go, right? So what Tawney's saying is, how could it be, right, that when they say all men are created equal? But I want to focus on citizenship for a minute, right? Not just persons, right? I want to talk about citizenship for a minute. I think Cassandra's next, unless you really want to say something. Cassandra, you want to, what Tawney focuses a lot on the distinction between people and citizens. What text does he bring forward for that? He puts a lot of effort into this.
It says,
Focus on the text of the Constitution. Yeah.
well, he says that in general terms, the few of the United States and citizens of several states, that the exercise of the power granted and the privilege conferred to the citizens.
No, not exactly looking for Sam. Yeah, okay, give me those clauses, please.
One of these clauses reverses to each of the 13 states the right to enforce slaves until the year
1808. Yeah.
Everything proper in importation
Yeah. So Tawney. Yeah, thank you. So Tawney makes a couple textualist arguments. He says, look, the Constitution doesn't treat all the people equally. It has, we talked about the Migration Importation Clause in Article 1, Section 9, and it says the migration of such persons can't be permitted by Congress before 1808. Now, it doesn't say slaves there, but it says such persons, and anyone who was literate would understand what that was referring to. How can it be, Tawney says, that such persons are meant to be citizens if they can be imported the same way you would import chattel and cargo and merchandise? All right? That Congress can't restrict it, that the states have a right to import these at least until 1808. It was abolished in 1808. Then we go down to Article 4, Section 2. And we discussed this provision in Prig, if you recall. And it says, no person held to service or labor in one state escaping into another shall be discharged. Again, it doesn't say no slave. It says no person held to labor or service, which is, again, if you're a literate human being, that means slave. So Tawney says, even in the text of the Constitution, there's evidence that slaves were treated otherwise. Yeah, Sam?
Isn't that we talking though about the prisoner as well? Under this clause, no person held in service or labor, because back then.
Well, look, you have two clauses, right? You have this one right above it, and it says no person charged with this treason, felony, or crime shall flee from justice. That's probably the indentured servant who runs away, right? This is a provision which is not dependent upon any conviction or any charge. It's merely an existence that you're bound to labor. So if you look at how this phrase was understood, it meant slave. I can give you amount of evidence this high showing that that meant slave.
I don't know if it's true, but were there, like, if you owe debt to someone,
And there were indentured servants. There were indentured servants. So,
does that mean you lost your citizenship if you became an indentured servant?
no. This is nothing about citizenship. It merely says that you can't be discharged from your labor. Right, so if you're, I guess, okay, so I don't know if it happened, but, all right, let me put it this way. Congress enacted the Fugitive Slave Act, which allowed slave catchers. I am not aware if they enacted a Fugitive Indentured Servant Act, which allowed people to go kidnap runaway indentured servants. I mean, it might happen. I'm just not aware of it. Fair enough? Maybe it did. I don't know about it. But the point that Tawney's making is, if you look at history, right? The Constitution, the Declaration says all men are created equal, and they were not treated as such. You have the Migration Clause. You have the Fugitive Slave Clause. You have the 3/5 Clause, right? For other persons are deemed only 3/5 for purposes of taxation representation. So Tawney says, look, we have a Constitution that treats these people differently. Okay. Those points are not wrong, right? I think he's actually making fairly obvious textual points. After this, he kind of jumps the shark because he goes way. No, you don't like jump the shark?
I like it.
Yeah, Adrian.
Never heard of it.
Never jumped the shark? You know the reference? Who knows the reference? I know where it's from. Jump the shark. What show is that from? Come on. Happy Days. We're Fonzie. Hey, you ever watch Happy Days? Oh, you're my nice. What was that, Adrian? Yeah, we're Fonzie. There was an episode where Fonzie was on a water ski, and he actually jumped over a shark. It was disaster. Okay, I'm done. Adrian.
If 3 was referring to slaves, is there a reason why it just didn't say no slave?
The reason why it didn't say that is they didn't want to put the word slave in the Constitution. So they use euphemisms like bound to service or labor.
I mean, if it was okay, if we're trying to make all mistakes.
Oh, what a good question. Why do they use slaves?
Why? Because if you're not used implies you anticipate either there's gonna come a change and you don't want to be held to that at the time.
Oh, what a good question.
It was wrong. And if that's the case, then it should have been dealt with at the time, because I'm thinking if I say no person held in service of labor in one state, back to his point, if you're held in labor and you have to do your time, you can't escape that. So that would be slaves or indentured servants. So
You're thinking like Frederick Douglass and Lysander Spooner. They were abolitionists. Yeah, you're in good company. So these were very good company. These were abolitionists who made the argument that Adrian's making. The document doesn't use slaves, so let's read it in a way it doesn't talk about slaves, which is precisely what you're doing. And let me make this point bluntly. There's a lot of historical evidence on what the framers thought about this issue, and they all recognized that they were doing something morally wrong. Consistently. Jefferson, Madison, go down the line, right? They all did it anyway, and we can judge them for whatever they did. But they, at least in their correspondences, recognized that this was wrong morally. And by framing the document in this fashion and not using the word slaves, maybe they hoped at some point the world would change, which I think is Adrian's point.
this was not sustainable.
They knew it wasn't sustainable, which is why since 1808, they gave them 20 years saying maybe this will be fixed in 20 years. Not quite, right? But they knew that. Even Jefferson, he wrote about this. When he says all men are created equal, he recognized that the contradiction that he was writing. But by putting something into words, by putting a pen on paper, or pen on parchment as it were, you're making a statement that future people can live up to it, right? If you watch the 14th Amendment video, which I think I posted, Randy has a very good line at the end where he says something like, they made an aspiration, a promise that didn't quite get there. And it wasn't until the 14th Amendment that this issue was at least textually resolved. Whether it's resolved, we can argue about that next week perhaps. But the text was not fixed till the Reconstruction period. Okay? So Tawney goes and he says that people of African descent are not citizens of the state, even if state law says they're citizens. And this is, I think, probably one of the more arrogant parts of the case, right? He's saying, because of nature and inherent differences by our Creator, that a state cannot bestow citizen on an inferior person. They can't. Even if they pass a statute calling someone a citizen, they're not a citizen. They're not. They can't do it. Okay? So that's enough to resolve the case, right? At that point, he's made the case that Dred Scott cannot be a citizen of Missouri, and therefore there's no jurisdiction. But he keeps going. All right, Adrian, I think you're next. You're next. So, well, okay, I'll. So, Adrian, the question is this, right? Pawnee can stop right there, but doesn't. He then goes on to address the other question. What was the effect of bringing Dred Scott to the federal territory in Wisconsin, Fort Snelling, right? Does Tawney think that bringing a slave to a free territory, which Wisconsin was, emancipated the guy?
No.
Okay, tell me, why does Tawney think that bringing Scott to Fort Snelling didn't affect an emancipation?
Well, that goes back to his point that the example you gave about North Carolina and Massachusetts, that if one state could not grant citizenship to a slave, his personal conversation with God, they were inferior and therefore could not qualify as a citizen. So how can you give citizenship to someone?
But this is not state I'm talking about here. I'm talking about the federal territory. Wisconsin was not a state at the time.
Oh, federal.
Fort Snelling. The issue is a little bit different for a federal territory. Because Congress enacted a statute, right? The Northwest Territory, the Missouri Compromise. And Congress also said in its own territories, the territories are free. So again, we have two issues, right? Can Congress, by statute, the Northwest Compromise, say that these northern states are free? And can Congress regulate its own federal territories, Wisconsin, and say this federal territory, Fort Snelling, is free? So, Adrian, my question for you is this. Does Tawny think that Congress can regulate slavery within the federal territories?
Does he think they can regulate
Slavery in the federal territories?
No.
Okay, tell me why not.
Well, if they're free territories, but they can't regulate slavery, I'm not sure, I guess. I'm not sure really what you're asking me if...
Let me ask one more time.
Okay.
Samantha, I'm sorry, so Adrian, Samantha, you're on deck, but before my next question in my head. So, Adrian, what gives Congress the power to regulate slavery in Wisconsin, the federal territory?
In the federal territories.
Yeah.
The fact that they're considered property.
Samantha?
I'm not sure.
Anyone?
Article 4, Section 3.
Okay, I'll come back to Samantha. Yeah, Tim.
Page 52, Article 4, Section 3.
The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state.
Okay, so we have this clause of the Constitution. The Constitution says Congress make the power to regulate the territory of the United States, or the property belonging to the United States. This was the provision under which Congress regulated the federal territories. They enacted provisional governments and various things like this. Tawney makes an argument, and this is, I think, I don't want to rank them, but this is a pretty crazy argument. He reads this provision, he says, Congress has the power to make all rules and regulations respecting the territory or property belonging to the United States. Follow me here. Tawney makes a grammatical argument. He says the Constitution was ratified in 1789. This clause only gives Congress the power to regulate property that belonged to the United States in 1789. Everyone follow me here? Right? It's a grammatical argument, right? I had one student looked up last year, whatever, I don't care about the grammar. But he says, Congress can only regulate the federal territory that belonged to the United States in 1789 when the Constitution was ratified. Which would mean Congress has no power whatsoever to regulate any property that's acquired subsequent to 89. What that means for federal territory, I have no idea. Right? I guess you can have totally local governance with no federal control. That can't be right. But Tawney says, look, belonging. The effect of that conclusion, which I think is wrong in every way, shape, and form, is that Congress can't prohibit slavery in the federal territories. So by virtue of bringing Dred Scott to the Fort Snelling, it affected no emancipation. Again, there's no jurisdiction, right? The usual way federal courts operate is that they only resolve narrow issues. Can you say John Roberts, right? They try to resolve things on narrow ground, statutory issues, right? Here he's doing the exact opposite. In a case in which there's no jurisdiction, He's making findings about provisions of the Constitution that have never been interpreted and that conflict with almost, 70 years of practice by that point of how the country had operated. That Congress made all these statutes regulating these federal territories, and Tony said, no, you guys can't do that because you acquired it after 89. Yaren, you're very upset by this.
Nobody argued against that. Like,
there was no argument on the other side. The government did not take part in this case. I want to just make this point very clear. The case was called Dred Scott versus Sanford. Not Dred Scott versus United States, not Dred Scott versus Department of Government, whatever, versus Sanford. The other side was a New York slave owner. He declared unconstitutional federal laws without any input from the U.S. government. I've looked into this. They may have filed a brief or something. They didn't argue for sure. I tried to find the answer to this.
but even aside from the slavery argument, which is the main point of this, nobody thought, oh, it might be a good idea for the government to be able to like control the stuff that we get. Nobody thought that was like.
The government didn't add any perspective in this case. They weren't a party to the case. No, it's not just stupid. I think
Coward. It was coward.
I like that word, coward. I like that word. I was going to say devious, which is a little bit meaner than cowardly, because usually when the Supreme Court considers a federal law, they invite the views of the government. So let's say, I sue you over something that implicates federal law. What the Supreme Court will do is say, hey, Solicitor General, file a brief, tell us what the interests of the United States are. The U.S. government wasn't bound by this decision. And the reason why this matters, I'm going to jump ahead a bit. Lincoln, right? Abraham Lincoln made this point when he was running for president. He said, this case involved Dred Scott and Sanford. It did not involve the U.S. government. Therefore, the U.S. government was not bound by the judgment. Whoa. You like this argument now. Wait till we get to desegregation. Wait till we get to it. But one second, Tricia. Let me make this point one more time, clearly. Dred Scott, the case, declared unconstitutional the power of the federal government to regulate the territories, even though the federal government wasn't party to the case and had no argument to present. No one raised this point. Tawney jumped off the end and reached all these very difficult and I think complicated constitutional issues without jurisdiction.
Exactly, Lincoln, separation of powers was just gone. He was just reaching over into.
He's not. I didn't get to Missouri Compromise yet. That's next, but yeah. And Trish, your hands up. Sorry, I skipped over you.
No, could this actually apply to anyone though? Because the actual ruling in there's no jurisdiction. So how?
But that's what Lincoln argued. The only holding was a lack of jurisdiction.
Yeah. So even though the government wasn't a part of this, does that even matter? Because there's no jurisdiction, so nothing of this actually is accurate.
Marcus and Kenesha? What do you mean, because there's no jurisdiction? Well, I think, again, the holding could have just been dismissed for lack of jurisdiction. One sentence. You got to hear the case and dismiss it. Kenesha?
Well, I wasn't going to say anything about that, but since you mentioned it. So that's just back to the point, right, that he had to reach, right?
Yeah, he had to.
That's the whole point. What I was going to say was, so I was thinking that too, right? This could really, the case could apply to anybody. It could apply to any ethnicity because because of the way that it was worded. And in here, he talks about the fact that it was done for safety. So, we want everybody to be safe, right? So it doesn't just apply to one group. And so I think there were arguments to be made just based on some of the things that he said because his argument was so broad. Mm-hmm. And I don't know that he was so smart that he wasn't because he was so broad with his argument that you could go so many ways with it.
That's a good point.
And it can have a completely opposite impact.
Yeah, Yaren.
So when you're talking with Janice about them being cowards, do you think that it was, well, do you think they knew that this would trigger the Civil War? Because that makes a good, I guess what I think is, I think they were cowards and they didn't want to put their foot in their mouth or declare something the wrong way and then kick off the Civil War sooner than it did. Is that something that...
It's really hard to know. Cause and effect, butterfly effect, right? Terrible movie. I don't know. I don't know. But Tawney, this much we can say about Tawney, he wrote about this. He thought that this decision would settle the issue and would prevent this from trickling back up. He wanted a clean resolution. All right, so we have so far two major constitutional holdings, right? First, that people of African descent can never be citizens. Second, that the property clause means Congress can only regulate the territories that existed in 1789, which is just a nutso holding, right? Then we get to the Missouri Compromise. This is probably the only argument he makes that still gets any sort of mention in any sort of cases, right? The Missouri Compromise said that states north of a certain line, 36 parallel, would be free, and states south of the 36 parallel would be slave. Who am I up to? Samantha, I think you're up. Yeah. Samantha, let me ask you this question. According to Tawney, what gives Congress, or why can't Congress enact the Missouri Compromise? Why can't Congress designate certain states as slave and certain states as free? Why can't they do it? It's not a structural thing. It's actually something you really haven't studied yet.
So he says that the powers of the government and the rights and privileges of the citizens are regulated and plainly defined by the Constitution itself. I think he was saying to regulate that.
Well, let me ask you this question, Samantha. So let's say, a person brings a slave to a northern state, and that person's then emancipated. What grievance might the slave owner have in that situation? What provision of the Constitution does that run afoul of?
Would it be the fugitive? No, not fugitive.
I need to scroll in advance. Yeah, okay. Read it for me, please.
Nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation.
Searcher?
Okay, so the Fifth Amendment was understood to be applied to the federal government,
Yeah.
not to the states.
Correct.
So that's why we have the 14th Amendment, where we have the same due process clauses applied to the
That came later.
Right. So then, if the owner takes a slave to a free state, then where does it say that the state?
It's the Missouri Compromise was a statute.
Okay.
And the Missouri Compromise said under congressional power, we're designating these states as free and these as slave. It was the federal law, not the state law he was striking down.
Okay.
Understand? Let me explain this point again. Everyone, Sergio says, wait a minute, Josh. Fifth Amendment doesn't apply to the states. That was Barron against Baltimore, right? The Missouri Compromise was an act of Congress. I'll show you the map, right? The Missouri Compromise said states north of this line, this green line, would be considered free, and new states admitted south would be slave. What Tawney says, and just follow me here, Congress lacked the power to enact that statute because it violated the Fifth Amendment. I said it again. Congress could not enact the Missouri Compromise and designate some states as free because it violated the Fifth Amendment. Why? It deprived slave owners of their property without the due process of law, and it affected the taking of property without any compensation. That is, if you were living in that territory and it became a state and became a free state, your slave just got emancipated, you lost property value. And therefore, it was unconstitutional. Now, we haven't done the due process clause yet. We'll do, oh my God, so much due process, you'll lose your minds, right? But generally, the word process is understood to mean a trial, right? If the government wants to take away your property, they have to give you a hearing, a judge, a jury, some sort of process. Tawney employs something a little bit different. that came to be known as substantive due process. Right up there. Usually think of procedural due process. Tawney gives something called substantive due process. The idea that the word liberty in the Constitution has a substantive component. That is, certain laws are so unfair that they violate due process. If you don't understand that now, don't worry about it. We'll spend a lot of time on due process. But Tawney's often accused of inventing this idea of substantive due process, which is false. A lot of Southern politicians had developed this argument for years in reports to Congress, that the federal government lacked the power to emancipate slaves because it would violate the Due Process Clause. So Tawney didn't make this up. He basically just plagiarized it from some Southern politicians. So, but he often is, Justice Scalia would always make this claim that Justice Tawney invented substantive due process. Why? I'll connect it in a very short distance. We'll do in a couple weeks Roe v. Wade and the abortion cases, right? The abortion cases are premised on substantive due process, that a person has a liberty interest in abortion. We'll get there in a few weeks. So there's a very strong movement to connect the substantive due process in Roe back to Dred Scott. Right? You'll often hear people compare slavery and abortion, and this is usually the connection they're talking about, which I don't quite understand. But they say that because the doctrine was invented in Dred Scott, it then must be evil because it was also used in abortion, back and forth. But substantive due process existed long before Dred Scott. Tawney did not invent it. It existed in American courts for quite some time. We'll get there later. But Tawney argued that the Missouri Compromise itself was unconstitutional, that it violated the Fifth Amendment's Due Process Clause and probably Takings Clause also, to deprive a person of their liberty and property without the due process of law. Now, wait a minute. Elia, what is glaring about the argument that emancipating a slave violates the liberty and property interests of the slave owner? What's just glaring that should be like big neon lights, like neon, like Las Vegas, right? What's just like jumping off the page with that one?
What's wrong with it?
Yeah, yeah. What's so obviously wrong with it?
Well, I mean, they're not property.
Beyond that, right? Yes, I'm sorry, that's correct. But what else? If the slave owner has a liberty interest, ...
Yeah, where is their liberty?
The slave, yeah, thank you, exactly. The Fifth Amendment doesn't speak of citizens. The Fifth Amendment says no person, right?
Right there, because that's his biggest point.
The Fifth Amendment doesn't speak of, here, go look at it.
They're not people. That's his biggest point.
Where's my constitutional at? Oh, I gave it away yesterday. Oh, I gave away my constitutional one yesterday. I'm actually homeless. I gave away both my spares. You guys are so beautiful. I love all of you so much. But anyway, it's in my anyway. I don't need it. But it says no person, right? It speaks of persons in the Fifth Amendment, not citizens. So to the extent you want any sort of logic from Tawney, I wouldn't expect that to find. He's acknowledging that people have certain liberty interests, but he denies this, which is why, Janice, why?
Because Africans and their descendants are not people. That's
Bingo.
his biggest argument. That's the whole point of what
Yes,
he's talking about.
because he knew that he has to get to this point eventually,
Yes, and he couldn't do it in the beginning, and he got to it.
which is why he has to go off the deep end.
Page 778.
Thank you, ma'am. He has to make the point that these are not human beings, because otherwise they'll be protected by the Fifth Amendment. Look, Frederick Douglass, Lysander Spooner, the abolitionists, they argued, hey, fugitive slave clause is depriving me of liberty without due process of law. They argue that. It's not a hard argument to make, but they're not people, they're not citizens, they get neither. Due process, they don't get due process, they don't get privileges and immunities, they get bupkis. Zippo. Bupkis. Nothing. Right?
I have a question.
Please, yes.
Okay, so the Missouri Compromise part.
He declared it unconstitutional in the case of no jurisdiction. Yeah.
Right, that was the second part of his argument. And so then my question was, if the case was, if Dred Scott had no, there was no diversity of citizenship,
Nope.
and the court really, I mean, they couldn't hear it anyway.
Nope.
How can he then make a decision
Insane.
on the Missouri Compromise?
Insane.
Okay.
I don't. I don't say this lightly. I'm not just doing this to criticize it, but it is such an abandonment of the judicial role to take a case where there's no jurisdiction and, number one, strike down Congress's power to regulate the territories, and number two, strike down the Missouri Compromise, which is holding the country together with these seams, right? Without the U.S. government being a party to the case. This wasn't a case where a slave owner brought a challenge to the Missouri Compromise. Right? This wasn't a case where a slave owner challenged the federal territory law. This was a mundane emancipation. I don't mean mundane and boring. It was a fairly regular suit between a slave owner and a slave trying to seek emancipation. These were fairly common at the time. And he made this into this ginormous case where there was no jurisdiction. Why? That's the question. Why did he do this?
Why did Marshall do that with Marbury versus that?
But so she asked about Marshall and Marbury. Marshall didn't actually do anything. Right? The bottom line of Marbury is Jefferson didn't have to do a damn thing.
Yeah, but his all it required was
What? No jurisdiction. There are similarities. I think Mia makes a similarity, right? In Marbury, there's no jurisdiction, so why did Marshall do all this other stuff?
Like you said, reaching.
There was a lot of reaching in both cases. Carrie?
Figure out like why he's doing all this. Is it just a matter of ego, or do you think that there might be somebody who's backing him during that time or something like that that would make him really dive into this?
You know, I can't psychoanalyze too much, but what I can tell you from historical records is that he thought this case would resolve the slavery question once and for all.
But I mean, his word is gonna.
He didn't care about it.
You know, let me put it this way, right? Let me put this elsewhere. When you're in a position of power where you're not checked, sometimes you lose your better senses, and sometimes ambition runs its own course.
But it was also, don't you think, it was also a check on Lincoln as well?
Lincoln wasn't in office yet.
I mean, but
Lincoln wasn't anything yet.
The concept,
Abolitionism.
Right. The whole it was larger than that. I mean, it was not. It was to get rid of the problem that was coming in terms of pushing against slavery. Like, I mean, now you just have it on that's the Mason-Dixon line, isn't it? Isn't that the same? You just have it on that line, right? And they want that, one side wants that line to grow in one way, another side wants that line to go the other way. And so that's, it was a push against it. I mean, it was a complete, let's end this right now.
Mia?
I have a question.
Mm-hmm.
So with the Article 1, Section 9 and Article 4, Section 2, Clause 2 in the Constitution,
Mm-hmm.
and the 3/5 compromise of the making part people count for white votes. What is the role of the judiciary in terms of like the Constitution and as it was with these conflicting parts, what is the role of the judiciary now? Like, what are they supposed to do? Not what did Taney do, but what...
I think that, to be perfectly frank, if Taney believed that Dred Scott was not a citizen, he should write a one-page opinion saying dismissed for lack of jurisdiction, moved on with his life. Wait till a case comes back up from a state Supreme Court, and then do this insanity. But in this case, there was no justification. But he didn't want to wait even a year for another case to come up from a state Supreme Court. If this is an appeal from the Missouri Supreme Court, there's not an issue, right? There's a jurisdiction by virtue of the state law.
So did this start in like a federal district court?
Exactly. They started in federal court. Exactly. I saw another hand somewhere. Who put a hand up somewhere? All right. So let's just try and I want to try to synthesize the major holdings of Dred Scott. So we first off say that people of African descent are never citizens. Second off, we say that the federal government can't regulate new territories. And third, he goes out of his way and says that the Missouri Compromise violates the Fifth Amendment. And all in the case which lacks jurisdiction, which is not so. But then there's a final part, right? What about the fact that Dred Scott, that's for Tim, what about the fact that Dred Scott was brought up to Illinois? The Dred Scott was brought up to Illinois, which was a free state, right? And under Illinois law, he should have been emancipated. How does Taney handle it? That's very briefly at the end.
So his opponent's considerations, it's intended to report that the act of Congress which prohibited citizens holding and owning property, it's not warranted. Basically said he makes almost the same argument.
But specifically, why doesn't his travels to Illinois, I'm not talking about Missouri, the free territory anymore, Why does not his travel to Illinois render him emancipated? Because under Illinois law, he's emancipated. That's my last question for at least the majority. Probably not more questions. But that was yeah.
The states can naturalize.
No.
The intent was not to be a permanent resident.
No, it's much more simply. Yeah.
Didn't say like it went out in Missouri, so whatever it was in Illinois it was that, but then it came back in Missouri, so it's governed now.
Governed by Missouri law. That's right. That's the answer. Missouri law governs. And again, I mentioned this earlier. Under the law in Missouri, it was changed. This was Chris and I had this conversation a couple minutes ago. The Missouri Supreme Court reversed itself in this case and found that they no longer applied the law of the forum, the foreign state. They applied their own law. And under Missouri law, according to the court, it was a violation of public policy to allow emancipations. So basically, again, Tawney closed up every single door. He even said, we're going to allow state law to trump the foreign law of Illinois so that they do not permit emancipation. Again, this entire case was premised on no jurisdiction. And he tried to foreclose every conceivable basis on which a slave could be liberated. Every door, right? By going to a territory, by going to a free state, by an act of Congress designating certain states to be free. Every conceivable basis, every pathway was blocked off by this decision. This is why it was 100 and something pages long. And he had to, again, to Janice's point, I think stated quite well, say that they're not even people. Otherwise, they would get Fifth Amendment protection in the Due Process Clause. So he closed up every conceivable avenue. They don't get privileges and immunities. They're not protected by the Due Process Clause. They can't be free by going to a territory. They can't be free by being brought to a free state. Zippo. That's it, right? That's it. I mean, there's a lot more, but I mean, that's in a nutshell. Kenisha, was that a hand?
Yeah, so the naturalization law, when he talked about how the naturalization law was passed on the first section of Congress, and that it was referred to, like, it was confined to the right of citizens, or people becoming citizens that were aliens and free white people. And then he talked about Indians and how he said that the law was confined to only.
I just one at a time. Yeah, thanks.
How the law was confined to only free white persons. But then he says, but it could have Congress would have had the authority to naturalize Indians.
Mm-hmm.
Well, but that's not right. So that's like a bit of a contradiction in itself, right? So you say that this law was created to only do, naturalize a certain race, but then you say, but it would be plausible that you could naturalize this other race, but nobody would have thought about it because they were too stupid to ask, is essentially what he said. But that's a contradiction in... Well,
actually, if you think of the 3/5 clause, it treats the other person separate from Indians, because Indians count for 0.
Well, then he's tackier than I was initially thinking.
Tackier. We got cowardly, we got tacky. I like it. Tacky. All right, what else? Who else got other questions on the majority? I'm going to move on to dissents in a minute. Any other questions in the majority in Tawney? Any other? Oh, behind me. No, I don't think. Any other questions in the Tawney majority before we move to the dissents? All right. I have a question. Monique, Markia, and then Clay. Yeah. He said that under Missouri law, a person who travels to a free state does not become emancipated, and that's the law he's applying. Right? Even though Missouri changed its law for this specific case.
Right.
Clay?
How did Tawney get his hand on this case in the first place? I mean, it was never appealed to the Supreme Court, right?
No. The first one in state court, Dred Scott never appealed it. The second one filed in federal court was appealed to the Supreme Court.
Oh.
So there were two actual cases. When I was in law school, I actually read the Missouri Supreme Court decision on the choice of law question in a separate class called Conflicts of Law. Very, very different opinion. It wasn't about slavery, it was about choice of law. It was about slavery, but not like this. All right, anything else in Tawney? Look, it's 90 minutes of majority opinion, but I tell you, it needs its own class. I could do a semester on this class. I could. No? You know they handle it? I could do a semester just on the Reconstruction period. I would love to do a seminar just on the entire, deeper, much deeper. I got to be very superficial here. All right, who's next? I think Monique, you're next. You got a stay of execution for a few minutes, and now you're back. So can you please walk me through? Let's start with the dissents.
Okay.
Good.
He said that, well, first he starts off talking about jurisdiction, and I guess saying that the court just said that there was no jurisdiction and that would have been the final say on everything, but of course that didn't happen.
Mm-hmm.
He talks about how there are other states, and the next dissent talks about it too, that already have black people functioning as like voting members and equal. There are 5 other states that do that, and they participate, and so that's evidence of them being citizens.
Yeah.
He goes down to talk about how Madison, when they were constructing the Constitution, I guess didn't want to. I guess they didn't mention slaves because they didn't want to say that there was a person's property, and so they avoided that. Let's see what else.
That's good. Yeah, that's good. That's good. I think most of the major points, right?
Okay.
But the vote was 7-2, right? This wasn't a 5-4 decision. I mentioned earlier that virtually all the presidents were Southerners. And at the time, when a justice was being appointed, their view on slavery was quite important. So a majority of the court were actually Southerners pro-slaves. And Maryland, Tawny was from Baltimore, from Maryland. Maryland was a slave state, even though you think Maryland's like in the middle somewhere. It was a very strong slave state. So Justice McLean had one of the dissents, and he basically ridicules Tawny. He says there's no jurisdiction. What are we doing here? He also makes the point that the interpretation of the property clause is insane because it basically means that there's nothing Congress can do to regulate its federal territories. Now, the second dissent by Justice Kurt. Oh, yeah, Kenisha, go ahead. Good point. Yeah.
I mean, so, if you're gonna, that's where it's like you're trying so hard to make this point that you don't even realize the implications of what you're doing.
That might be like the indentured servant point Adrian made a little bit ago.
Yeah. You can't. So there you go. All men are created equal. They can all be slaves.
Yeah. I like it. Very good. All right. Justice Curtis wrote the other dissent. He was so disgusted by the majority opinion, Dred Scott, he resigned from the Supreme Court. This is the only case that I'm aware of where a justice resigned out of such disgust with the Taney decision. But he just peaced out. He said, I can't do this anymore. Funny story. No, he didn't say peace out. I said peace out. But he said bye. He just dropped the mic. He actually went on to represent Andrew Johnson during his impeachment trial, which is a fun fact. Okay. Let's talk about the Curtis dissent. Who's next? Trisha, you want to give me the Justice Curtis, please?
So, like you said earlier, you could tell in his writing that he was just discussing the proposal. He talks about when the Constitution was adopted, that it was adopted by all people of the United States, under each state. He talked about a little bit how some of the states have different requirements for black individuals versus white individuals, and it seemed to me he would even say that was wrong, that there should be an equality across the board.
Yeah. He makes a historical point. If you read Taney, you think that basically all 13 colonies and all 13 states were segregated, and that simply was not historically accurate. In fact, at the time of the ratification, 5 out of the 13 states gave the franchise to people of African descent. That's almost half, right? They were citizens in those states. And there were some states like Massachusetts which abolished slavery in the 1780s. So it simply wasn't the case that the Constitution was ratified for the white person, as I think he frames it. He also makes the point that Missouri basically was wrong to change their own law. And I think he criticizes the Missouri Supreme Court for basically flipping their own decision for the purpose of this case, although, that's the state court's prerogative. You'll learn this probably later in law school, but the Supreme Court can only review federal questions. If there's a decision from a state Supreme Court that's based on an adequate and independent state law ground, then the federal Supreme Court can't touch it. So state Supreme Courts have a monopoly on their own laws. Now, if it violates the federal Supreme Constitution, federal court can step in. But if it's an adequate and independent state ground for decision that doesn't involve federal law, then there's no Supreme Court review. This is a fairly important bar. But this case implicates federal law in a big way. Okay? All right, but yeah, again, he was just livid. Okay. All right. Go ahead, Mia.
Do we need, on either of the dissents, do we need to dwell on their discussion of Prigg and the municipal law aspect?
Yeah. I mean, Prigg, I mentioned this when we did Prigg last month. In terms of effect, Prigg had a much bigger impact on the slave issue than did Dred Scott.
But they're at odds, because Prigg says whatever the law of the municipality is governs.
Yeah, so it's this weird dynamic where under Prigg, the states can't protect slaves, but they can reinforce slavery, right? Under Prigg, Pennsylvania couldn't provide protections for these people, but under Dred Scott, free states have to accept slaves. Let me try. I said that poorly. Let me say it one more time. Under Dred Scott, a runaway slave can be returned back south, right? I did it wrong again. Let me try it one more time. Under Prigg, a runaway slave can be returned down south. But under Dred Scott, a slave brought north can't be emancipated. So it only went one way. I think you did that correct. Yeah. It only went one way. A runaway slave had to return south. A slave brought on his own with his master couldn't be emancipated. So basically, again, it's a one-way ratchet to keep slavery in place, not to eliminate it. Yeah. Eliminate it. Oh, it's a long day.
You wanted to eliminate it.
Oh, yeah, Kyle.
Yeah, so I was going to ask about, I think it is Article 1, Section 9, maybe off the top of my head, the one about not prohibiting importation of slaves until 1808.
Yeah.
So is that not inherently recognizing that the federal government does have the power to, at some point after 1808, forbid the importation of slaves? And if that's the case, then they also have the power to regulate once they leave the United States, or that state, by going to the United States territory, they have the right to regulate property. In other words, to destroy the title of the property.
Let me ask another question.
To my question?
Yeah, unfortunately, I'm not going to answer a question. I'll give you another question.
All right.
What gives Congress the power to exclude people from the United States?
It's vested by the other states, basically. What do they say, entrusted? So it's
What enumerated power gives Congress the ability to stop people at the border?
There is one about immigration. And
it's about naturalization, which means citizenship.
Right.
I have a paper on this now. It's in. I'll come back to you in a second. What gives Congress the power to deny entry at the border? Is that a clause? Naturalization is about citizenship. I think that's the best answer. I think it's a necessary and proper means to have an effective naturalization scheme. I have a paper on this. One of my law professors wrote this paper, very provocative, that argues that Congress has no power over immigration. They can only do naturalization. And I think as a necessary and proper means to have a naturalization scheme, they can deny entry. But Kyle, to your point, the fact that they can't deny entry before 1808 means they can exclude after 1808. Oh, anyway. So I didn't answer your question, but I think it's a good argument. Creative. Thank you. All right. Anything else on the dissents? I want to do the post-Lincoln stuff. Anything else on Dred Scott? We did good. Yeah, Marquette, please.
It's a random fact again.
Please.
But, so 18 months after this decision, Dred Scott died of tuberculosis, and so he never
No, he wasn't. I think Harriet was. Kristen, am I right on this? I think Harriet was emancipated.
His kids were not. His kids were. His wife was not.
Was Harriet not?
That was the long.
Google me on this. Someone should Google. I think, because I vaguely recall that Harriet worked in a hotel somewhere in St. Louis after this case. I vaguely remember reading that, but I'm not sure.
I thought that the abolitionist husband purchased
Harriet and emancipated her. I think that's right.
because he sold they bought it because he was embarrassed.
Just one at a time. Yeah. And again, Emerson's wife married this abolitionist, and he didn't quite know what he was getting himself into. All right. So any other questions on Dred Scott before we move on? Yeah, Drew.
So I know in the video they mentioned there was an angle that the question was asked was the Constitution that allowed them to, was it the Constitution's fault why we got to this decision, or was it the Supreme Court that was in power at the time? Your opinion on that? Do you think the Constitution at the time when this was passed, they had this ground to stand on? I mean, there was a lot of fluff, a lot of hypocrisy.
Yeah, I mean, look, it's a good question, right? If the court had issued a one-sentence opinion saying that Scott was not a citizen, therefore dismissed for lack of jurisdiction, that could have been a plausible decision. I don't know if it's correct, and the dissents make good points, but the Constitution's silent on who is a citizen. Everything else, I think, is batshit.
Right.
It's crazy, right? It was off the deep end. But the narrow issue of who was a citizen, as a historical matter, the slaves were not given privileges and immunities. That part Tawny was right about. And they were not given the right to bear arms, the right to free speech, et cetera, et cetera. So that, I think, is evidence that they were not citizens of their own state. And under state law, they weren't citizens. So that probably the narrow aspect was probably plausible. But again, the 14th Amendment fixed that. I'm going to get there in 1 minute. Yeah. Everything else is nuts, right? But just the narrow holding, you probably have to go to state court for that case. Now, if Dred Scott arose from a state court decision, I think it'd be a completely different story. But the narrow diversity of jurisdiction issue is different. Thank you for the question. Yeah, I always put these nice questions in the videos. We don't answer them for you. I think you actually ask me, which not everyone can do. Okay. I'm here. You pay tuition. That's what you get. You get a live human being. Now, other people use our book and they don't have me to ask questions, so you get this for free. You get me. You get me. And me and Randy may not agree on that point either, so I haven't asked him. We don't always agree on questions. We agree on 90%, but not everything. All right, so what happened after Dred Scott? The decision was universally reviled. And it was also largely ignored. And let me explain what I mean by that. One aspect of Dred Scott was the holding that the federal government could not control the territories that were new. Does anyone think that Congress stopped regulating the territories for a minute? No. Did Congress say, oh, crap, Supreme Court said we can't regulate these territories. Let's abolish all of our laws in Wisconsin territory. Do you think that happened for a minute? No, it didn't. Dred Scott held the Missouri Compromise was unconstitutional. Do you think Congress said, all right, let's go declare all the northern states slaves? Do you think that happened? No. The decision was basically ignored. Right? It had almost no legal effect. It had a huge effect politically. But the legal effect was nil. And this is why I say as a practical matter, Dred Scott was much less significant than was Prigg. Prigg had meaning. Those slave catchers went around and did their thing because of Prigg. But Dred Scott, people were aware of it, but it didn't change the law. But here's what it did change. It changed the political debate. Because Abraham Lincoln and the nascent Republican Party in 1860 rose to power on the platform of attacking Dred Scott. And we've all heard of the Lincoln-Douglas debate. Now, who are Lincoln and Douglas? That was not the presidential election, which people mistake. They were elections for Senate in Illinois, Lincoln and Douglas. And Douglas made the argument that, well, the Supreme Court spoke and we have to follow it. The Supreme Court spoke, that's the law of the land. Whether I agree with it or not, that's the law of the land. And Lincoln made a different argument. Now, it's often said that Lincoln said we have to ignore Dred Scott. Not accurate. The same way he didn't ignore Tawney in Merriman some years later, he didn't ignore Dred Scott. Let me explain why. Dred Scott v. Sanford was a case involving two people, Scott and Sanford. The U.S. government was not a party. Didn't present any arguments, wasn't bound by the judgment. What Lincoln said was, limit the holding in Dred Scott to the two people in the case. Limit to those two people in the case. All the discussion about the Missouri Compromise and the territories is other business. Okay. You, Dred Scott, well, he was passed away, but you, Mr. Sanford, you can't enact the Missouri Compromise. Okay, so what, right? You, Mr. Sanford, you can't deprive someone of the due process of law. Okay, so what? So Lincoln said, let's limit the holding to the parties of those cases, and that way the U.S. government's not bound by the decision. And he argued this viciously, very strenuously. Now, people say, yeah, go Lincoln, right? I just want to give you a preview. We'll do a case in about a week or two called Cooper against Aaron. This was a case decided in the aftermath of Brown versus Board of Education. Brown involved 4 states, Kansas, Delaware, Virginia, and South Carolina. Okay? Involved school boards from 4 states. Brown versus Board of Education, right? It was school boards from 4 states. Arkansas was not a party to Brown. Therefore, was Arkansas obligated to comply with Brown? So what happened? Black children in Arkansas sued the Arkansas School Board. And there's a judgment from court saying you have to integrate. So then the governor of the state shows up, Orville Faubus. And he says, I am not going to allow integration to happen. And he puts in state troops to block the children from accessing the schools. Okay, so they get a court order against the governor and the state troops. Then the local police department show up. Says, aha, we're not bound by the judgment. We're going to deny entry to these kids. Okay, then they get a judgment against them. At this point, President Eisenhower sends in the 101st Airborne, federal troops, to enter and escort Little Rock 9, these 9 children, into high school. You've probably seen the pictures walking up those steps, right? It was a state National Guard, yeah. He federalized the National Guard. They were actual paratroopers. They paratrooped into Arkansas. But the arguments that the segregationists raised in those cases were the same sort of argument that Lincoln used in Dred Scott. So it makes people very uncomfortable. It's like, yay, go Lincoln. Limit the judgment to the parties that are bound. And then when the segregationists are like, well, that's not what I meant. So just keep that in mind. It's a very uneasy. I don't have a good word for it, but it makes people a little bit queasy when you can take the Stephen Douglas perspective that the Supreme Court's the final word. Brown, final, right? Or you take the Lincoln saying, well, we'll wait and see. Now, it's based on, well, that decision was right and that decision was wrong. But, people thought one was right, one was wrong. People thought Brown was wrong for a long time. And by the way, after Cooper v. Aaron and the Supreme Court said that the children have to be admitted to the Arkansas high schools, they basically shut down the schools for a year.
I have a fun fact because I used to work in Arkansas as a teacher.
Oh, were you?
So, yeah. I was
in Little Rock?
No. So I was in Geek for America, so we had to go to Little Rock and do the little tour thing.
Oh, you went there. Good.
Yeah. But I worked in Lake Arkansas. Population 2. Anyway, so there, and I lived in Mississippi, and so in those 2 places, especially in Little Rock, Arkansas, it's still very much so segregated. Like the school is still very much so black. And if you go to places like Mississippi or Arkansas, at least where I was, it's almost like you're traveling back in time because it's crazy. It's still very much so black, white over here, separate, and they know it. Everyone knows it.
Yeah.
Just fun fact. Sorry.
Not so fun, but it's a fact.
Yeah.
So that's Lincoln. What happens next? Well, then we get to the Civil War. Make sure for class next week you watch the video on the adoption of the 13th Amendment. It's like 18 minutes long. It's almost like a sitcom. This is our longest video this semester. We put a lot of work into this. It's like really long. But it tells you the entire history. So I'll summarize a few briefly now. Shortly before Lincoln's inaugurated, several of the southern states declare that they're seceding. Lincoln was elected without a single Southern vote in the Electoral College. After his inauguration, several other states secede. And then we have the firing of Fort Sumter in South Carolina, which marks the commencement of the Civil War. Did Dred Scott cause the Civil War? I think it's an overstatement, but it definitely, I think, accelerated it. I think it's a fair statement. Fast forward several long, bloody years, and we get to the conclusion of the Civil War. I fast forward a lot of stuff, but summarizing. At that point, Reconstruction begins. And the phrase Reconstruction literally means reconstruction. They're reconstructing the nation in a radical way with the enactment of 3 provisions of the Constitution. 3 provisions of the Constitution which were ratified back to back to back. The 13th Amendment did what Lincoln could not do. We discussed the Emancipation Proclamation last week in the Executive Power Unit. The Emancipation Proclamation only liberated the slaves in rebel territory. It did not liberate slaves in Maryland, for example. 13th Amendment did it with one fell swoop. It says neither slavery nor involuntary servitude. And Adrian, this is your point, involuntary servitude. It also referenced it here. Oh, and white slavery too, that Kenesha mentioned. Neither slavery nor involuntary servitude, except as punishment for a crime. So chain gangs, right? Oh, Brother, Where Art Thou? You ever see that movie? Yeah. Chain gangs were allowed. Shall exist within the United States. This was the first provision of the Constitution that limited not just government action, but private action, that private individuals could not hold slaves. Now, I'm going to just preview this issue. What does slavery mean? Does that only refer to chattel slavery? Or does that refer to maybe conditions or incidents or badges of slavery? Would segregation constitute slavery? Big debate. We'll do that one next week. Okay. The 14th Amendment had 5 sections. We already did Section 5 and with respect to sovereign immunity. But I want to mention Section 1 now. Each provision of Section 1 of the 14th Amendment nullified an aspect of Dred Scott. Okay, let me walk through this one step at a time. Nullified. Section 1 of the 14th Amendment, each provision of Section 1 of the 14th Amendment nullified an aspect of Dred Scott. Got it? So first, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That just killed Dred Scott's holding in diversity jurisdiction. If you were born in the United States and you're subject to the jurisdiction thereof, that means no ambassadors' children, for example, you are a citizen of the United States. And this is retroactive. It's not people born after a certain year. If you were born, you're a citizen. Not just of the United States, but also of the state wherein which you reside. Which means you get your diversity jurisdiction. You get your butt in federal court now. Right? You are now able to go to federal court to vindicate your rights. It's a big deal, right? The first sentence nullified Dred Scott. And because you're now a citizen, you get certain rights. The next sentence says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. What are these rights, these privileges and immunities? We'll discuss it next week with Slaughterhouse, which some of you may have read already. But this guaranteed that the freedmen, as they were called, got the same rights as the white citizens. They cannot be deprived of citizens, those privileges and immunities. So again, Tawney made a big fuss saying, yes, they can't be citizens because they don't have these rights. Well, now they got the rights and they're citizens. Right? Sentence by sentence, it wipes out the holding of Dred Scott. Okay, the next provision. Nor shall any state deprive any person of life, liberty, or property without due process of law. I think Sergio asked me this question a few minutes ago. Under the Fifth Amendment, only the federal government was prohibited from depriving people of liberty without due process. Now the states were. Right? The states no longer deprive you of your liberty without due process of law. Then we go to the last part. No state shall deny to any person within its jurisdiction the equal protection of the laws. Now, this is a provision which I think people don't understand exactly what that meant. It means something today very different from what it meant before. Today it means the laws to apply equally to people. Applies the same to white people and black people. The key word there is actually not equal, but the key word is protection. This was about protecting people from like the Klan and racial violence. The states had to protect their citizens from lynchings. This is actually what the clause was understood to mean. It's taken on a completely different interpretation today. We'll get there when we do Strader next week. But that wasn't all. All this stuff, no state, no state, no state, Congress did not trust the states to take care of business. They fully expected the southern states to enact racial codes once they got back in power after Reconstruction. So they added a very important part, Section 5. And we discussed Section 5 with boring stuff like, religious freedom and, violence against women, boring stuff. The biggie was to ensure racial equality after the Civil War. And Congress would enact statutes that did a couple things. Would allow these new citizens to go to federal court and sue for their civil rights. And would allow federal prosecutions of state officials that deprive people of their rights. And would allow Congress to enact laws, perhaps desegregating different acts of society. Right? Today we think of the 14th Amendment as something the courts administer. That's not exactly right. It was for Congress to pass laws to ensure that this provision was given its full effect. They could pass appropriate legislation. Sounds like necessary and proper, doesn't it, right? Pass proper legislation, appropriate legislation, to ensure the provisions of this article are enforced. That means Section 1 of the 14th Amendment. So we will spend the rest of the semester basically on this 2 paragraphs, right? So we'll do crazy stuff with this, but that's the basis. And then, I don't have it up here, but the 15th Amendment was ratified a couple years later, which guaranteed the right to vote without respect to race. It did not give women the right to vote. That will come many years later with the 19th Amendment. By the way, many of the suffragists who worked with the abolitionists were kind of pissed off at that, because then what about us? There was actually a huge schism when they said we can't ratify something for suffrage for women because it won't go through. So there was a huge actually divide among the abolitionists and the suffragists who've been working together for years on that issue, as it were. All right, so where are we? Okay, so the 14th Amendment's ratified. Your reading for next class is a little bit long, but discusses the Slaughterhouse case, which is a very important decision where the court basically deleted probably the most important aspect of Section 1, which was a Privileges and Immunities Clause. The court just ignored it from the Constitution. Anything else? I will see you all next class. Thank you.